Now, joining us on the program, very pleased to have with us Steve Hallberg, Second Amendment attorney and scholar. Steve, thank you, sir, for coming on the program tonight.
Glad to be here, Cam. You always call me when there's some bad news of some kind.
Yeah, I know. Sorry. Well, it's not that. It's I call you when I hear about a case that I don't know much about and I want to learn more about it. So I go to the people who know more than I do. And Steve, you're one of the brightest guys I know here. So help me figure this out. A few years ago, Congress passed the Protection of Lawful Commerce in Arms Act, which says you can't hold gun manufacturers and sellers for the third-party actions of criminals any more than you would, hold Ford Motor Company or the local Ford dealer responsible for some guy stealing a Ford from the street and then driving drunk and getting in an accident and killing somebody. And yet we have a ruling by the Appellate Division of the New York State Supreme Court that says a individual who was shot in 2003 in a crime may sue the companies that manufactured and distributed the gun that was used in the crime.
That's right. They're back. And the Brady Center has gloated that this is the first time since the act passed that a manufacturer has been held to be potentially liable for the misuse of a gun by a criminal. And you know why this is the first time is that the other courts have been abiding by the law. The law that Congress passed, Protection of Lawful Commerce and Arms Act, says that if a crime is committed by a third party, a criminal, you can't just sue the manufacturer. That's what the Brady Center was doing to try to put the legitimate firearm trade out of business. So get it. Listen to what happened in this case. B. Miller makes the firearm, a 9mm pistol, High Point brand, sells it to MKS Supply, a distributor. They sell it to a federally licensed firearms dealer, a guy named Brown.
Mm-hmm.
Sold some guns to somebody else, a non-licensee, and somewhere down the line, a gang member got this gun, a normal 9mm pistol, and shot someone else. And so who gets sued? Everybody. Now, maybe the fellows who sold it to the criminal, maybe they were criminals. I don't know. I don't think there's enough known about this case. But certainly, B. Miller, the company that makes High Point firearms, federally licensed firearms manufacturer, they shouldn't be held liable for this. This is exactly what the law was passed to prevent. Now, there's an exception for if you knowingly violate a state or federal statute, the marketing of the product. Well, of course, if somebody knowingly violates the law, sells to a felon, they should be held liable for the acts that are foreseeable. And so they make the allegation in this complaint that the fellow who sold the guns, at the lowest level to the criminal, they knew they were violating the law. That's probably true. So they should just be the only ones sued. But how do you get around to suing B. Miller and then the distributor, MKS? You say that ATF has traced your gun a lot. Well, that was the theory that they had used to try to sue manufacturers originally. And, hey, guess what? If you make a lot of guns, your guns will be traced more. And consider the fact that being traced doesn't mean it was used in a crime. It just means that somewhere in this process of investigation that a gun was traced. It might be that an old lady turned in her deceased husband's guns to the police, or it might be that somebody was busted for an IRS violation and they seized the guns in the house. I mean, this is exactly the kind of decision that was intended to be precluded by the act of Congress.
So, Steve, how did the judge reach this ruling?
Well, they go through the complaint and they spend all their time talking about the fact that the guy at the lowest level who sold these guns, that he knew or should have known he was selling them to criminals. And that might well be the case. But then the three judges say very little when it comes to how can you allege sufficiently that the manufacturer foresaw this or broke the law. They say things like this kind of gun is disproportionately used in crime. Hello, it's just a 9mm pistol. They say it has no collector value. Well, the Supreme Court said in the Heller case that handguns are useful for self-defense, and that's what's protected by the Second Amendment. This is the same kind of mush that we used to see years ago when they started bringing this theory up to sue the manufacturers for the acts of other people, when you know and I know the majority of guns, overwhelming majority of guns, are used by law-abiding people for lawful purposes. So there is no legitimate reasoning in this decision.
Okay. So what happens next then? Where does the case go back down for trial? Does the appellate division of the state Supreme Court's decision get sent up to the state Supreme Court for review?
It'll go up. There'll be an attempt to have the case reviewed by the next highest court. In New York, for some reason, the Supreme Court is a low court. But I'm sure the defendants here, the manufacturer, will try to take it up further. If that's accepted, then there'll be a new ballgame. And if it's denied, it'll go back for discovery. In other words, the people making these claims about the illegal conduct are going to have to prove something. It's one thing to say something in a complaint,
right?
Something totally different to prove it. How are they going to prove that this manufacturer that's licensed by the ATF to manufacture guns, and you can bet your bottom dollar that they would be out of business if they were breaking the law? They get inspected by ATF. How are they going to prove that they did anything illegal? They're not going to be able to. So, because then you'll have the lawyers filing papers, motions for summary judgment, they're called, where there'll be some discovery and there'll be a total absence of any evidence of illegal conduct by the manufacturer and most likely by the distributor and maybe by the FFL dealer. We don't know. There's not enough known about this case. But the way the law is supposed to work is that at the earliest stage, these cases should be dismissed so that they don't just be used to harass industry people to put them out of business.
Yeah. All right. Well, listen, Steve, I see this is why we have you on the program, so you can. I couldn't have explained any of that.
Well, as smart as you are.
No, listen, I really appreciate you coming on the program talking about this. And I know that there's a lot of other cases that you're working on. Anything else that we need to get caught up on in the next couple of minutes that we have?
Well, we're contesting the ATF letter, demand letter that went to all the licensees in Texas, Arizona, New Mexico, and California, requiring them to report more than one sale of a rifle if it's semi-auto and if it has a detachable magazine. So, Congress passed a law many years ago saying that if more than one handgun is sold within a 5-day period, those reports go to ATF.
Yeah.
And now Congress didn't write this law, though, to say that if more than one rifle of a certain type is sold, that those are reported to the ATF. We have strict guidelines against a registration system in this country, and the ATF is basically, on the one hand, they're letting guns go to Mexico under the Fast and Furious program, intentionally letting that happen, and then they're blaming the dealers and saying that the dealers have to report sales of that where people pass the background check, they pass the NICS check, and if they buy more than one of a certain kind of gun, then they have to report it to the ATF. So we're challenging that. It's being challenged in the District of Columbia Circuit. It's being challenged in Texas and in New Mexico.
All right. Well, listen, Steve, thank you again, sir, for coming on the program. Always a pleasure, and look forward to doing this again very soon.
And thank you for having me, Cam. Thank you
bet. Second Amendment scholar and attorney Steve Hallbrook